Welcome to the session on strategic litigation as part of the Young Lawyers Making Change Festival. I'll just briefly introduce myself. I'm Katie. I'm a solicitor at Liberty, but I'm chairing this session in my capacity as a former Justice First Fellow. I trained under that scheme at the Public Law Project, which is co-hosting the festival. In today's session, we wanted to take a look at the idea of strategic litigation. And as Shu Xin says in her paper, which Amelie is circulating now, the idea of strategic litigation has become a bit of a buzzword amongst lawyers and in the legal world recently. And it's this idea that you can use existing legal frameworks to bring about systemic change, and that by picking the right case, you can bring one piece of litigation that will have a wider impact on a group of people. It's also increasingly contentious as the government is accusing lawyers of somehow trying to subvert the political process by challenging unlawful government policies in this way. So in today's session, I think that we're going to try and just deconstruct that concept a bit, look at some of the myths around strategic litigation, as well as examining some recent case studies of where litigation has been used really effectively. And those case studies are going to be particularly in the context of trafficking and immigration detention. So I'm really delighted to have a panel of brilliant lawyers here. First of all, just to say that unfortunately Zoe McCullum is unable to join us, but as we were ambitiously planning to hear from 4 lawyers today, I think that we'll still be able to have a really in-depth discussion amongst us. Before we get started, I'll just introduce each panellist. Each panellist is going to speak for 10 minutes, which will hopefully leave quite a lot of time for discussion amongst the panel, as well as time to take questions from the audience. So first of all, I'm really delighted to have Shu Xin Liu from Garden Court speaking. Shu Xin is a bit of a legend in the public law world. She's particularly well known for her expertise in anti-trafficking work and her work on the rights of migrants to access support, housing and education. She's been Legal Aid Lawyer of the Year, as well as Junior Pro Bono Barrister of the Year in 2019. Our second speaker is Aisha Christie from Matrix Chambers. Aisha is also an expert in the kind of intersection between public law and immigration. Along with Shu Xin, she acted for one of the claimants in the case of K and AM, which was a challenge to the rate of subsistence support provided to victims of trafficking. She has been working with Detention Action and Duncan Lewis recently on their really important work trying to safeguard immigration detainees during the coronavirus pandemic, and I'm looking forward to hearing a bit more about that specific work in a moment. And then finally, we've got Rebecca Kingy, who's representing the more junior end of the profession. Rebecca's a solicitor at ATLU and a YLAO committee member. She's a New Zealand qualified solicitor who's been working with victims of modern slavery in the UK for the last 3 years, and as well as carrying out public law litigation at ATLU, she coordinates their parliamentary engagement work. I'm mentioning that because Zoe was going to talk a bit about some different strategies of trying to bring about systemic change through the courts versus Parliament, and in her absence, I'm hoping to hijack Rebecca to talk a bit about campaigning and parliamentary work, if we have time, as well as her strategic work at ATLU. And so on that note, I'll hand over to Shu Xin.
Thank you, Katie. I hope you have the notes that I've done on the chat box. Essentially, it kind of covers a lot of the things I'm going to say, but I just want to keep to my 10 minutes. As Katie said, strategic litigation has become a buzzword. I mean, it sounds really glamorous. It's very exciting. It sounds much more exciting than ordinary litigation. And better yet, you get tarnished by the government as an activist lawyer. But what is strategic litigation, and what makes litigation strategic, and how do you measure that? What I want to do in the short time that I have is to demystify this phrase and show that strategic litigation is not a species of its own, and certainly not something reserved specifically for some lawyers and not others. So it's not like a holy grail of sorts in a way. Because if you strip it down to its bare bones, litigation is really strategic because it achieves an outcome that benefits not just one person, but many. This can be done in a variety of ways that I want to show, either directly and deliberately or indirectly. And really, it's capable of describing pretty much any kind of litigation, particularly in the public law and human rights world, where the complaint is directed at the exercise and abuse of power. So I want to look firstly at the first type of what I call traditional strategic litigation, where an organization brings their expertise to subject matter and brings that challenge in the name of the greater good. And I want to start with an early example before all of our time. Is a refugee legal centre in the Secretary of State for Home Department, which was a challenge to the implementation of an accelerated asylum process in immigration detention for asylum seekers on arrival. And it set down some really important principles, although it wasn't successful, about what fairness requires in a process. And this was then built upon in 2014, so 11 years later, by Detention Action challenging the detained fast track again, the back end of it, and the structural unfairness of the appeal process, which deprived detainees of the opportunity to advance their asylum claims. And all of you have heard about JCWI's right to rent case, which was also one of those direct and deliberate challenges to a hostile environment policy. So that's the first traditional case. The second case is what I called hybrid cases, where litigation is advanced by both an organization and individuals to achieve a common outcome. The benefit of this type of case is that it combines the expertise of an organization who has historic and institutional knowledge about the complaint, and individuals who have compelling experiences illustrating what's wrong with the issue. It's not without problem, because you're coordinating multiple legal teams, multiple individuals, and everyone with different interests. And the X factor, so to speak, to their success is the ability of everyone to collaboratively work together. An example of this is the European Roman Rights Centre case, again, an old case, but one that illustrates this really well, about a scheme that was implemented in Prague airport. This is sort of the beginnings of the end of the hostile environment, basically. And it was a way to process asylum claims before the asylum seeker even gets on a plane and gets to the UK, to sort of stop them from even happening. And then you've got more recently the case of Medical Justice and 7 others, which both Aisha and I were involved in, which challenged the Home Office adoption of a narrow torture definition as a part of a framework that was supposed to be protective of those who are in immigration detention. And the narrow definition meant fewer detainees got identified as vulnerable, and fewer of them benefited from the safeguard against detention. I acted on behalf of Medical Justice, who had done a lot of lobbying in advance of the Act coming into force, on how to make it better. And so they had a lot of historic institutional policy knowledge about how this framework developed. And then Aisha represented 5 of the 7 individuals who were excluded from protection by reason of this narrow definition. And it required quite a lot of coordination and collaborative working. And in the end, together, we were successful. So that's an example of the X factor working to help the greater good with a combination of people. So the last category is what I say and want to encourage people to think of as the most common, and should be the most common category. And that's just individual cases. Individuals who are affected by decisions and frameworks that the government has implemented, but the effect on them speak to wider issues than their individual facts. Sometimes this is easy to identify at the outset. Sometimes the wider impact is identified through repeatedly bringing cases to the court's attention. I think that this is the bulk of litigation, which, if you think about it in the right way, is strategic. And it is the kind of case that may be a bread and butter case, but actually has a higher impact. And I want to give 2 or 3 examples in the time remaining, but I've set out a few more in the note that I did. And the first is the case of Matheson, which is a case about a disability living allowance payment that got suspended if the child stays in hospital beyond 84 days. And when this rule was introduced, campaigners were really, really vexed about it and knew that this was going to be a problem, but didn't really know how to get at it. They did a lot of the policy work, a lot of campaigning and raising awareness about the problems, but it really took a little boy staying over 84 days in a hospital and his parents losing disability living allowance and working their way through the first tier tribunal, the upper tribunal, the Court of Appeal, and eventually to the Supreme Court, which finally ruled in that individual case that it was a discriminatory rule and it had no objective of justification, because what's the difference between the needs of a disabled child who's in hospital for 84 or less days and someone who's in there for over 84 days? And that Supreme Court judgment, brought by an individual through a painstaking appeal process, ended up changing the law. Another case I wanted to illustrate the indirect impact of strategic litigation is a case called VC and the Secretary of State. And that relates to mentally ill immigration detainees who couldn't, because of their illnesses, challenge their treatment in detention, the use of segregation, and the challenge was to the effect on that individual VC that it was a breach of equality duties to make reasonable adjustments. Although it wasn't pleaded as a strategic case, as in like this needs to change for everyone, that was the implication, because there was an absence of provision. So if it's discriminatory towards him, it's discriminatory towards all. So the judgment spoke for itself in terms of its direct and indirect impact on a wider cohort. And the last case I want to give an example of is actually a favorite of mine, a colleague of mine in Chambers did this case. It's called the No DSS litigation. And this is, I think, an important illustration of how hard graft in individual cases bring about significant change. No DSS, DSS stands for Department of Social Security, which hasn't been in existence since the 1970s, but it still was used by landlords as a way to reject tenants who are on benefits. And the research from Shelter was that 63% of private landlords would refuse to rent to those on state benefits. Shelter started supporting people to bring claims for discrimination against this practice over the course of 2 years. Most of them were settled with the landlord or the estate agent seeing the light of day before they get to court, paying out compensation and agreeing to reconsider. But one eventually went to trial, and a district judge in Yorkshire made the first landmark ruling that this practice applied to the claimant was unlawful and in breach of the Equality Act 2010. And although on its face it's just a county court claim applied to an individual, it showed for the first time what such a discriminatory practice could go unpunished, and it's couldn't go unpunished, and it sent the right message to landlords and estate agents in terms of practices. And that itself is sufficient to start a serious discussion about something that was not only morally wrong, but unlawful in law. So just to wrap up in my 32 seconds, what are the common threads running through all these three types of litigation? Well, what I would say is ask the right question. What is your complaint? Who does it affect? What do you want to achieve? What looks like ordinary case may not be so ordinary. See the DSS litigation. Identify the right storyteller. Sometimes the facts speak for themselves. Look at Matheson, and look at another case called K and AM that Aisha and I were both involved in that I have referred to in my note. Sometimes context matters. Look at the Refugee Legal Centre case or the Medical Justice case. Know what you want to get out of it and why. A case can as strategic litigation, but not achieve generic relief so that the case is vulnerable to re-litigation. And VC is an example of this because there subsequently was another Court of Appeal case which ran the same point and had to be litigated in the same way. But contrast that with K and AM, which I referred to in my note, where generic relief led to victims of trafficking getting a back payment of £1.5 million in cuts. Alternatively, a case could lose in the courts. And I think this is a point picking up on what Zoe was going to say, but it could lose in court, but provide an important legal context for policy change. And I did a case for Liberty called Against Borders for Children, which challenges school census collection of nationality data. And we lost in court. But as soon as we settled the case, the Secretary of State for Education decided to change the regulations and stop nationality collection. And Aisha's going to pick up on the detention action litigation recently as well. And my final 2 points are short, and it's don't take no for an answer and don't accept the status quo. And the other is collaborate and think laterally. And this is important because a point that I want to get across is that litigation is one of the many ways in which you can affect change, and sometimes working in partnership with other lawyers, but also frontline people and policymakers, you can actually bring about much more effective change sometimes. So thank you very much.
Great, thanks, Shu Xin. I'll pass straight on to Aisha now and save questions for when you've all spoken.
Hi everyone. So I'm going to talk about one of the cases that I was involved in earlier this year, the challenge brought by the NGO Detention Action to ongoing immigration detention during the coronavirus pandemic. So this case was one of the toughest cases that I've worked on so far, largely because of the speed at which we had to prepare the case and go to court. It felt like we'd done several months worth of work in a 2-week period. But it's a good example of the sort of work and importantly, the teamwork that goes into preparing a policy challenge. I'll start at the beginning. Back on Wednesday, the 11th of March, the World Health Organization declared a global pandemic. And as we all know, at the time, the UK government was very slow to act, and it seemed to be business as usual with the Home Office. People of all nationalities continued to be picked up by immigration enforcement and taken to detention centres across the country, notwithstanding the risk of infection. And the day after this, I got a phone call asking, would I be interested in bringing an urgent challenge to the ongoing detention of people who were particularly vulnerable to coronavirus, with Detention Action and Duncan Lewis solicitors. And first of all, I was asked, could I speak to an epidemiologist who was based in Bangkok and ask him whether he would provide us with an expert report and give us an idea of the underlying medical basis for the grounds of challenge that we could advance. So I had a call with Professor Richard Coker. He's the Emeritus Professor at the London School of Hygiene and Tropical Medicine. And he agreed to write us a report on the risks to detainees from COVID. And all of us in the legal team very quickly had to get to grips with the medical terminology, understand what the scientific community knew at that point about how COVID was transmitted. We had to understand asymptomatic transmission, pre-symptomatic transmission, and the risk that detention centres as congregate settings could accelerate the spread of the virus, both within the centres and within the community at large, and potentially contributing to an even bigger public health disaster. So once we had an idea of what the medical experts were saying about the risks from COVID and specific risks within detention centres, we were able to formulate our grounds of claim and send a pre-action letter off to the Home Secretary. And as many of you will know, the normal timescale for a response is 14 days, but we asked for a reply within 2 days, given the urgency of the situation and the risk to our clients. And as well as acting for detention action, we also made the decision to bring a linked claim by an individual who was held in detention, whose health problems meant that he was at increased risk of suffering serious infection or death if he contracted COVID. And as Shu Xin's already mentioned, this sort of linked claim often works well because the NGO client can provide a wealth of background evidence on how large groups of people are affected by a certain policy. But then having one or more individual claimants linked to the claim enables the court to consider how the policy directly affects individual detainees. So we sent off the pre-action letter and then got on with preparing further expert evidence, which we needed to constantly update because the situation was fast developing and the government began producing various policies. And we needed to ensure that by the time we got to court, all the evidence we were relying upon wasn't out of date. So within a 10-day period, Professor Coker produced 3 expert reports for us. And as I said, he was based in Bangkok, but in fact, the time difference worked really well for us because he was able to produce his reports while we were sleeping. And then we were able to get up in the morning, review them and file them with the court. And in addition to Professor Coker's very helpful evidence, we had a couple of other expert reports, one from a public health doctor in the UK that addressed the strain on the NHS from increased numbers of people contracting COVID. And we had another report from a doctor with expertise in immigration detention who addressed the risk that the record system used by healthcare in detention centres wouldn't pick up on underlying medical conditions that would put detainees at increased risk, which would make it harder for these individuals to be identified by the Home Office. And so whilst normally these sorts of reports are produced over several weeks and there's normally a bit of back and forth and the issues are clarified, we literally had to turn these around in a matter of hours. And as well as expert evidence, we prepared a number of witness statements from the Director of Detention Action, who along with her colleagues and other organisations who are working to support detainees, were gathering accounts from detainees in various detention centres across the country of the unsanitary conditions and the risk to them. So we were being told by detainees that they weren't being provided with soap or cleaning products, notwithstanding that they were expected to clean their own rooms and clean the communal areas. No one had been given masks or gloves. There were detainees who had COVID symptoms, coughs, for example, who were mixing freely with everybody else within the detention centres. Very worryingly, just before we got to court, we even heard an account in one detention centre where all the detainees had been invited to congregate together at a free barbecue. And we heard that there'd been an outbreak of COVID at Colnbrook and Harmondsworth, but the Home Office official line was that this was simply a case of detainees coming down with seasonal flu. And all of this was very concerning, but the same narrative was confirmed before the Home Affairs Select Committee, although the Home Office did also confirm to them that no one in detention had actually been tested for coronavirus at that point. So we put all of this evidence in a number of witness statements to make sure that by the time we got to court, we had an up-to-date and complete picture of what was happening on the ground. And we spent less than a week getting our evidence together. And as we hadn't received a satisfactory response to our pre-action letter, by Wednesday, the 18th of March, we issued judicial review proceedings. And we argued firstly for the release of all persons whose underlying health conditions placed them at increased risk of suffering severe infection or dying from COVID. And we argued that the state has positive obligations under Articles 2 and 3 of the European Convention on Human Rights to protect individuals from a real and immediate risk of serious harm or death, as well as a duty to implement systems to protect such individuals. And secondly, we argued for the release of all persons who couldn't be removed from the UK as various countries around the world began shutting down their borders indefinitely. And because there was no realistic prospect of removing these people within any kind of reasonable period of time, the legal basis for their detention had disappeared. And we'd applied for urgent interim relief, and this included asking for an order that the Home Secretary release all detainees with COVID comorbidities, unless she could identify overriding public protection concerns in an individual case. And so we filed evidence with the court of the risks to vulnerable detainees, and we had expert evidence on the importance of acting quickly. And because of this, we asked the court to list an urgent interim relief hearing over the weekend. Now, this was quite unusual to ask for a hearing over the weekend, but we thought it was worth asking for it given the risk to our clients and the lack of action taken by the Home Secretary to mitigate the risks at that point. Unfortunately, our request for a weekend hearing was refused, but the court listed a hearing for the Wednesday of the following week. By this point, it's 25th of March. And in doing so, gave the Home Office additional time to begin implementing policies. The Home Secretary was ordered to respond to our application within 2 days, so by Friday the 20th of March. And by the time we got to the end of the week, quite a lot had been done. So large numbers of detainees had had their detention reviewed. By that Friday, approximately 350 people had been released. Again, on the Friday, the Home Secretary produced a policy for detention caseworkers. So detainees who had relevant comorbidities that placed them at increased risk from COVID were treated as being at level 3 of the adults at risk policy, which is the highest level, and that would make their ongoing detention much harder to justify. The Home Secretary also issued instructions to detention centres to ensure that Public Health England's guidance on hygiene was being followed. Detention centres were told to introduce social distancing and put in place individual care plans for people with underlying health problems. And then the Home Secretary also implemented a system of internal case progression panels to review the detention of everyone that remained in detention centres. So less than a week after we'd issued proceedings, we had the interim relief hearing. And around 7 p.m. the evening before the Home Secretary sends through her evidence, we have a late night going through several hundred pages of documentation. which isn't it's not an unfamiliar experience in these sorts of cases. But overnight, and then again during the course of the hearing, we had to tweak the wording of our interim relief application to take account of the government's fresh evidence about the steps they'd taken so far. So we argued, amongst other things, for the release of all detainees who were not removable from the UK, unless they were assessed to pose a high risk of harm to the public. And we had our interim relief hearing via Skype before a divisional court. This was just 2 days after the UK had gone into lockdown. And I think we might have been one of the first cases to be heard over video link. So it took about an hour for the technology to be set up in the morning. And then our hearing went on all day, and we had judgment handed down at 7 p.m. And as many of you will know, we lost. So the court refused our application for interim relief, found that the Home Secretary was acting promptly and prudently to identify persons at risk from COVID and review their detention, and also found that there was no evidence to suggest that the steps had only been taken in response to our claim. So it was all quite devastating. But then we took a step back and realised that although we'd lost, we'd actually achieved quite a lot by bringing the litigation. And in a sense, it was because we'd achieved so much that we lost the case. So by bringing legal action, we got the Home Secretary to release a significant number of detainees. And looking at the figures, back in January this year, there were 1,225 people in detention. By the 24th of March, the day before our hearing, there were just 736 people remaining in detention. And the process of releasing detainees continued as the detention reviews were conducted. We'd also got the Home Secretary to agree to treat people who were vulnerable to COVID as being at increased risk of harm in detention, and that made their ongoing detention much harder to justify and enabled individuals in detention to then bring claims arguing for their own release. And we forced the Home Secretary to put in place a rapid timetable for reviewing detentions and making decisions on release. And also through our litigation, we'd been disclosed a list of countries to which the Home Secretary was unable to remove people, which we almost certainly wouldn't otherwise have had sight of. So this was an example of a case in which, despite losing in court, bringing a legal challenge itself can actually force the government to amend its policies and practices and achieve practical results for your clients. But for me, this case was also a very good example of the importance of close collaboration in strategic litigation cases. And in all of the policy challenges where we've been successful in achieving results for our client group, collaborative teamwork, in particular when preparing the factual and expert evidence, which is often so important in these sorts of cases, has been really crucial. And in this case, as well as having a team of excellent solicitors at Duncan Lewis and a fantastic team at Detention Action, all contributing to the evidence, we also had helpful input from a number of other organisations working with immigration detainees and a range of medical input. And there was a real willingness by everyone involved to work incredibly hard under very extreme time pressure, which again is often necessary when bringing strategic cases. So I think I'm up of my time now, so I'll stop now, but happy to take any questions on a case that might come forward.
Great, thanks, Aisha. We'll move straight on to Rebecca now and then take some questions. In fact, I've got quite a lot of questions already. Take some questions after Rebecca's 10 minutes. Thanks.
Great, thank you, Katie, and thank you so much for having me here today. I think actually what I've got to say really builds on both of what our panel have already said already, and my starting point, perhaps somewhat biasly because I am a junior lawyer, is that I think that there's a myth that junior practitioners cannot be involved in strategic litigation, and I reject that. I think absolutely not, and strategic litigation can often be put on a pedestal like Shu Xin said, but actually what it boils down to is litigation that can have wider impact. And like it or not, as a junior lawyer, you might have a case that ends up on your desk that comes across and it's allocated to you, and it has a strategic element. And I guess the starting point of all litigation, really, we should be thinking strategically and thinking, right, what is the impact of this case? If I have to, run to trial, what's the wider impact going to be for my client? And I think we always have to sort of begin with the end in mind with these cases. But I think I want to sort of touch on some of the reasons why I believe that, why actually juniors shouldn't be prevented from doing this work, and why you should be excited about it and put your hand up for it, and look at this as something that could be a part of your career. is partly because the word junior these days is so, it's changed, it's evolved. I think that a lot of juniors actually aren't that junior. My experience in the UK has been that many people work for a long time as a paralegal before they even get a training contract or even get a pupillage. So you actually come into the profession with quite a lot of experience that you shouldn't undermine. I remember when I was a law clerk, which is like the equivalent of a paralegal in New Zealand, often the partner, I would say it was a very empowering partner that I had working with me, but that was because he was so busy. He would just ask me, what is the strategy for the case? You know, what are we doing next on this litigation? Because I was the one that had read all the documents, being the junior, and I was the one that was most up to speed with what the client was saying. So I think ultimately, don't underestimate your role and your significance when you're working in a legal team at being at the junior end as to what you can bring. I saw this comes hand in hand with saying, absolutely, experience in this profession is incredibly valuable. And, you know, we're really lucky, I think, in England and the UK to have so many experts in this field that have done some amazing litigation and have really sort of come across barriers and overcome them. So a good part is of just accepting, I think, when you're young and when you're old, is that we don't know everything, and that's okay. And when you're doing casework, especially when you're doing strategic litigation, that can have wider impact, negative or positive, on the client group and the wider sector, it's okay to say, I don't know. It's okay to ask for help. I think there's no shame in that, and it's something that we should be actively encouraging and, you know, sort of embracing, really, because the more we ask, the more we learn, and the better job that we can do. So this is a kind of wider comments, and I know this isn't a career panel, but I sort of wanted to start with that because I think it's something that many of us are excited about when we start in our law careers, that we can bring change through the judicial system because we're angry about injustice that we see, and this is a way that we can get justice for the people in our communities. So I don't want people to sort of lose that by the daunting idea that actually it's going to be impossible for me until I'm, you know, 20, 30 years into my career to have that impact. I reject that, absolutely not. But what sort of comes hand in hand with that is there's also, we need to move away from the notion that this sort of thing that strategic litigation is so sexy that you have to have this big media spiel and it's going to be this big headline. And of course, those cases are amazing and they're so important, but actually, it doesn't need to be that big to be effective for your client and effective for a wider group. And I think if we're sort of needing, if that's our aim in our career to have that, then I don't think we're going to be sustainable as practitioners, because it's almost the Instagram of the profession, seeing those press releases and those communications that come out, and it's almost selling it. Like, that's what happens when you're a good lawyer. But there's probably a lot of good lawyers that are just exceptional, and we will never know their names because the work they've been done hasn't attracted the journalist spotlight in that area, or, you know, they're not on Twitter. And actually, our satisfaction in this profession can't just come from that. That can't be our motivation, because we're probably going to get disappointed when we realize there is so much hard graft behind the scenes. And I think even hearing the work that has been recently done by the team on the detention action case, I imagine that you didn't sleep for weeks, and it was, you know, some lot of hard graft behind that. And I think we need to be alive to that and not pretend it doesn't go on behind the scenes. And it's a big part of building our resilience. So moving on, also, why have I got a right to be in this panel speaking about strategic litigation? I guess I sort of have been involved from three aspects, completely by accident, really. The first being actually working in the support sector. So not even working as a legal professional at that time. I moved to the UK and wanted to work with victims of trafficking specifically. That was the client group I wanted to focus on. And I soon realized, stepping out of legal practice and sort of into the front line with my colleagues, that litigation, strategic litigation, was just a huge key that had unlocked for my clients being able to access their entitlements. Because actually, the way that the systems were set up, there were not really many other mechanisms for people to get their rights recognized. And for us on the front line, us as support workers, as advocates for our clients, if we were getting pushback from sort of state bodies, the way that we could, you know, sort of combat that was to say, well, sorry, look at this judgment, look at this consent order. What you're doing is unlawful. And we'd managed to get results from our clients without even needing to get a solicitor involved on that specific case. And it kind of grew my passion for this, because I could really see how it was a very effective tool, not the only tool, but a very effective tool specifically for that client group. And it was eventually sort of seeing how many clients couldn't access legal advice and couldn't access people to help them unlock those barriers that were preventing justice, which sort of pushed me back into the profession and back into public law, specifically working with victims of trafficking at ATLU. And I think it kind of leads me to my next point that I want to focus on, and it's something that isn't really touched on at law school, but in all litigation, but it definitely in strategic litigation, relationships are so important. And I think being able to communicate well, not only with your team, but with your client, with counsel, and with other organizations is essential for these cases, because ultimately it can make or break a case. And I think some of the skills that I've found most valuable to me in the last sort of year working in this area haven't just been legal analysis. Of course, that's extremely important, but actually being able to work really closely with my client and approach a case in a way that they can understand. And I think regardless of your client group, you could be dealing with someone, you know, who's from a corporate world, you could be dealing with someone who doesn't speak English, that's an asylum seeker. And are you confident to speak to them? And are you going to be able to take the instructions that you need to further their case and understand what the key facts are? And especially if you're bringing individual cases like Shu Xin touched on, it depends on the type of litigation you're bringing, but if you are doing that client-led case, that is just so essential to actually being successful in this. And I sort of really encourage practitioners in this area, just if you're new, if you're starting out, get as much client time as possible. Put yourself in those situations, because you usually have to move very quickly. You've got to build trust and rapport very quickly. And you could be dealing with someone who, you know, has really been let down by the system many times. So coming across again as another lawyer, as another suit, can be a huge barrier. And I think learning to actually approach people where they're at is massively important as a profession, and we don't talk about it enough. And I know I talk very fast. I'll try and slow down. I get so excited about this work, because I just see how important it is for my client group and sort of the individuals that I work with, and I see, you know, how well and how sort of talented they are really at maximizing on relationships. And it sounds horrible to put it that way, but it's so important, because as everyone's sort of touched on so far, having partnership in strategic litigation is very key. So being able to actually understand the context that you're bringing the litigation in, so getting actually an understanding, not just about what's happening for your client, but what's happening across the sector. Is what you're fighting actually going to be beneficial, or is it actually going to create more waves? Is there another way to go around this? And I think asking other lawyers isn't always going to be the answer on that. Probably asking people that are in the field, that see what happens day to day, is probably going to be more of a route to get that evidence that you need and get a better understanding. So being somebody that can be approachable, can reach out and chat to people and actually build positive relationships is really important. And I think something that we forget all the time is the importance of saying thank you. So if somebody is giving you evidence, or somebody is taking time out of their day to actually support your litigation and support your case, it's very important to acknowledge that, to thank that. I know that we're busy, that counsel is busy, that everybody's busy, but I think that sort of thing is really important to cement that, because chances are, if you're specializing in an area, you will go back to that person again and again. I just wanted to sort of finish with a sort of few examples very quickly of my own involvement in this. And it goes again to that point of not every piece of strategic litigation will be a sexy case, potentially, on a big headline, but it has an impact. And so I worked in a case with Shu Xin this year, one of my first cases I issued on in the UK, actually, which was great to have someone so kind guiding me through. But for my client, it was specifically about him being able to go back into trafficking support. So he had been exited before a new policy had come in from the government, also as a result of strategic litigation, about victims of trafficking being able to have support reinstated. And so in the end, he was about to be homeless. He was a positively identified victim of trafficking. He was a very vulnerable man. And so he'd been asked, the Home Office had been asked through a charity whether he could go back into the NRM system, so the system for support for victims of trafficking. And there was a blanket no. There was no assessment of needs. There was no consideration of whether he would be eligible for this policy to have that support in place. And when we said, well, no, that approach is unlawful, we issued and we got interim relief. And in the end, actually, the Home Office conceded, and they said, actually, yes, he was entitled to ask for that support. And he was entitled to have it on the facts of his case. So that support did get reinstated. So we didn't end up getting a full judgment, because on the facts, we had to resettle the case. We couldn't take it any further, but we got a consent order. And I think for me, in my own world, where I'm, you know, every day working at ATLU, and we see so many cases and so many people that have just got barriers to justice, I get a lot of advice calls and calls from charities. And I had a call even just last week where a support worker said, you know, I've got a client that was in a similar position to yours, and they're going to be homeless. They need to go back into support, but I've had a blanket comment from Home Office on this that they're not eligible. So I could say, look, tell them that you think their approach is unlawful and attach the consent order, and see what happens. And she came back to me just 2 days ago saying, it worked, they said they went back straight away. And for me, that's what it's all about. That's absolutely what it's all about. It's like having that wider impact. It's empowering, you know, people that are working on the front lines with our client group to actually be able to unlock options for clients. And it's empowering clients as well. And for that client, I'll wrap up here, but I think this is the most encouraging thing for me. He's so chuffed. He's so chuffed that his case, that he was brave enough to bring, he was brave enough to say, what's happening to me is wrong, it's helping other people. And I think actually being able to communicate that to clients too can really help, because after having, you know, so much, I guess, pushback in life, to show somebody that what you've done and your bravery has made a difference. And our clients are the brave ones at the end of the day. They absolutely are putting themselves on the line. It's incredibly rewarding. So in summary, if this is something that you're interested in, absolutely go for it. Surround yourself with people that will encourage you. Ask lots of questions. Don't be ashamed of not knowing. It's so normal. It's so okay. And yeah, always begin with the end in mind. It's about the client, it's not about that sexy headline. And then I think you'll find it is a very rewarding area to be working in. Stop there.
Great, thanks all. I think, like, I've got a few questions, so maybe if I start with some questions for the panel, and then if you've got questions for each other, just chip in as well. I mean, I was going to start by picking up on something that Shu Xin said about the Matheson case, which you said painstaking appeal process that the family had to go through. And actually, I think Becky has kind of answered some of the questions that I had about that, but what I was going to ask was, how do you kind of reconcile that quite painstaking, very stressful, potentially kind of years and years long process, bringing a piece of strategic litigation as an individual with your kind of client's best interests, a client who might be a very vulnerable person, who might, you know, even if they have their own individual interests, it might be quite a huge burden for them to kind of carry that piece of strategic litigation and carry the burden of the potential benefit to a wider group.
I think it really depends on the client. I mean, I think you raise a very good point, because individual clients are very affected because they tell a story that's directly affected them. But at the same time, individual clients are oftentimes very vulnerable. So I think there a layer that one would add to strategic litigation is a sort of ethical layer of considering not every case, even if it's the best point and the best facts, should be the vehicle for strategic litigation, simply because someone is vulnerable and they do need to just be allowed to move on with their lives. And I think so sometimes, I think Becky probably can speak more to this, but it's about it really is about the striking the balance and trying to explain to the client what it is that you're trying to achieve on a broader level, what their role is, and it just takes the brave client to do that. And not to say that the person who doesn't do it isn't brave, but they may have their own personal circumstances. And it's that very fine balance that we do need to be very careful about, and when we're trying to achieve something wider, because like Becky says, you can't really forget that it is someone's life at the heart of it.
Thanks. Becky, do you have anything to add to that, or should I move on?
I think a few quick comments, and I think I find I'm learning on this all the time, and that's just natural. But I think, like Shu Xin said, there's obviously the very human element to factor in for your actual client's personal circumstances. Is this the best route for them and the remedy? And, you know, if this drags on, how are they going to sustain that? What support is in place for them? Court is very stressful, but they have somebody that can, you know, be there with them practically to go through the processes. And there's also the really, like, and it almost sounds cold, but the really practical aspect too. And that is, for example, the funding. So are you able to get everything that you need in terms to get your legal aid funding through? Because that can really hijack your timeframes around a claim. And I think there's been a question about that. And and how do you deal with the struggle of funding these cases? It absolutely is that. It is a struggle. And I think sort of always sort of preempting it, knowing it, accepting it at the start helps with dealing with that. So I always try and factor into my timeline, right, where is my funding application going to be? What happens if it's delayed? What happens if it's declined? What's my, you know, strategy going to be around that? Because it's better to think worst case and deal with it than pretend it doesn't exist. And obviously the evidential part of that, can the client access the evidence that you need for the legal aid agency? Do they have people in place to help them? The answer may be no. So it's trying to think about ways around that. And if there are not ways, it's trying to think about other routes for them. So I think even with COVID, the other aspect at the moment we've had is, can we take instructions effectively over Zoom or over the phone? And is it going to be, even can the expert, is a medical expert report going to be appropriate for this client remotely? And is it going to be strong enough if not? And it's having to think about those logistics all the time. So I don't think there's a one size fits all, but I think it's important to turn your mind to them, definitely.
Thanks, Becky. And yeah, there has been a question about funding. So how do you deal with the struggle of funding the cases? And particularly where you need to act quickly, as in Aisha's case. And I was going to ask a question about acting quickly, which is about the evidence that you needed to gather in the detention action case. I mean, you were obviously acting like extremely quickly, and we've seen in some judgments on kind of pieces of systemic sort of strategic litigation trying to achieve systemic change, is the courts really looking for a huge amount of evidence to kind of meet the threshold to show that a policy is unlawful. So, I mean, what were you thinking about when you were thinking about the evidence that you needed to gather in the detention action case, and how were you able to get what you needed at such short notice?
Yeah, I mean, I think sort of through doing the more kind of policy challenges you do, that the greater your understanding is of the way in which the courts are going to approach the evidence, and the sorts of things that you get to court having prepared your evidence, thinking that you've got pretty strong evidence, and suddenly the court says, well, there isn't any evidence of this. And that's the sort of thing that comes with experience. So really, like during the detention action case, we were sort of anticipating potential responses from the government, or then responding to policies that were being produced, and just ensuring that we were sort of shutting down potential lines of argument. And I mean, because all of this had to be done at speed, it was sort of using existing connections that we had with doctors, or sometimes it did involve approaching kind of new people we hadn't worked with previously. And there was quite a lot of goodwill, I think, to kind of get the work done quickly, get the work done over the weekend, or get the work done overnight. But we just had to be kind of as comprehensive as possible, just to make sure that our evidence, albeit produced within a 2-week period, was going to be kind of the quality that you'd be able to produce if you had the luxury of 6 months to prepare a claim. So yeah, we didn't really sleep.
Thanks. I'm not sure that's the best advert for strategic litigation, is you won't sleep for 2 weeks in order to get a case into court, but I guess that's the reality of working on an urgent
Well,
case.
most cases are not under such strict time pressure, so you have a little bit more time to prepare.
I've still got a couple more questions. I mean, again, for Shu Xin, you were talking about the no DSS case and Shelter's strategy of bringing lots and lots of individual challenges, kind of hoping that at some point one of them would stick. I mean, what do you do if you've got an issue which you think is, a policy or a practice that's unlawful, you want to challenge it, you don't have a kind of organizational client, so you're acting for individuals, and every single case settles? How can you kind of get across that hurdle to get something into court, to try and actually get a judgment that will have the wider impact, rather than just achieving something each time for an individual through the kind of quite agonizing process of applying for legal aid, issuing a JR, and then seeing it?
I'm not sure there's an easy answer to that, but at the same time, I think sometimes when you bring a series of individual cases, by virtue of doing that, you're already seeing the pattern. So that by the 3rd or 4th case, you can say, well, in the last 6 months, we've issued X number of cases, you've settled X number of cases, all on the same basis. This is clearly an issue that's not going away. And so you sort of take it head on in your pleadings when you do the 4th case, for example. So to give you an example, a case I did on as a trafficking case about a policy that the Home Office operated, which prevented people who had negative decisions from getting it reconsidered unless they went through a particular convoluted process. And when lawyers get involved and they look at the decision and go, oh, well, this obviously is wrong, they send a pre-action letter, invite the Home Office to reconsider. The Home Office goes, computer says no, because you haven't gone through this process that we've convolutedly created. And so we decided that actually we've had enough of this, and every time we then issue proceedings and challenge a negative decision, they cave. But it doesn't resolve the procedural barrier to getting just to get them to engage with reconsidering. So we then brought a challenge basically on the reconsideration policy. And we framed it as, we know you're probably going to cave on our individual case, but we're not going anywhere. We want to challenge this policy. So we got permission on it. And then sure enough, just the day before trial, they settled our individual case. But it's a combination of luck and just the way we framed the case. The judge who was supposed to hear the hearing, the Home Office tried to bin it off. The judge was like, no, and actually relisted it for a full 2-day hearing just on the policy issue, because we didn't have like a lot of evidence. We just had one firm doing 6 cases over the course of 12 months where the same response was given. And in each of those 6 cases, they settled. So all we did was produce those pre-action letters and those consent orders and said, there is a pattern here. This is not an anomaly. You need to hear it. So in a way, sometimes, this is why I say in the DSS thing, is sometimes things just click. And then you've just got one, in that case, my colleague was saying, you just had one estate agent who just stuck his oar in, refused to settle the case, and it went to court. And then it went to court, and you just need one case to go to court to go beyond the moral judgment, to say this is unlawful, for it to send the right message and for the domino effect to happen. And sometimes that is hard graft, and sometimes it clicks, and sometimes it works from the first go, sometimes it doesn't. But that's why I am quite keen to sort of emphasize that you've got to think about, this is why you ask questions for each case as to what you're trying to achieve. Have you achieved it? What else do you want to achieve at the end of that case? And then you keep asking that question, then the pattern comes up, and you can also bring litigation that is strategic through that process. I mean, it's a longer process, but you get there in the end. Yeah.
Thanks.
Can I just add something to what Shu Xin was saying? And that is, I mean, I often find that clients get picked off one by one when you're trying to bring a strategic case. But also, I think what's quite helpful is, because often these sort of policy issues are identified by different firms of solicitors and different barristers, and people are often start out working kind of individually. But what I think is very helpful is when we start sharing our evidence and sharing discussions about kind of our tactics, because it may not be my case that ends up being the case that goes to court, because my case may end up settling, but quite a lot of the work that we may well have done in kind of producing our evidence might actually be very helpful for somebody else's case. And certainly with a lot of the kind of trafficking work that we're all doing at the moment, there is a lot of kind of information sharing between barristers and between firms of solicitors, and of course all the NGOs and support organisations that assist us. And I think that's really helpful, because you know, we're all seeking the same outcome, and at the end of the day, it doesn't really matter whose case it is that achieves it. So yeah.
I was wondering, I mean, Becky mentioned like the Instagram of litigation, and I was wondering, we've talked a lot about collaboration, but on the flip side of that, do you ever feel that there's a kind of like bit of jockeying for the best cases, or is there ever tension between organisations about who gets to do the glamorous case, or who gets the credit, or who gets to do the kind of press release? Or is that not really an issue where everyone is trying to pulling together with the same goal in mind?
I'm going to be the brave person to say that we have to be realistic, and human beings are human beings. And obviously there is always that. But I agree with Aisha that, you know, in particular sectors like trafficking support and trafficking world, people are very collaborative and information sharing in relation to both policy developments and what the Home Office is saying about whatever latest creation of policy that they've come up with without any consultation. And so I think it depends on the area of law. I think it depends on the dynamic with the stakeholders, with the NGOs and the frontline staff. And if you've got a very strong and developed and well-established sector of organizations, it can make a difference, because it means that everyone, they sort of also help guide everyone to collaborate with each other, I think. Yeah. and resist the urge not to, kind of thing. I mean, it's human. Everyone's a human being, and I think it would be sort of lying if we don't all have some instincts in that respect.
Thanks. We've had a couple of questions in the Q&A, but I just also wondered if the panel had any questions for each other arising out of your talks or out of anything that we've talked about so far.
I mean, I was speaking earlier to these ladies about how, obviously, I'm sure many people are aware, the government are going to be looking at the remit of judicial review. So they've appointed an independent panel to look at this. And I think, you know, all the examples that have been discussed today show really how judicial review has been just a huge tool for people, you know, for the public to actually make sure that the state are acting lawfully and public bodies are acting lawfully. I'm interested in comments from the panel, and Katie included, about your thoughts around this independent sort of look at judicial review, and any thoughts on how as a profession we can be making sure the right narratives are being told to the public about what judicial review is.
Shu or Aisha, do you have anything to say to that?
Well, I think this is sort of sheepskin, a review. I'm not going to get in trouble saying that, but you know, I mean, it's a fundamental challenge to the principle of the rule of law and constitutional principles of access to justice, and the ability of the judiciary and individuals to question and monitor what the executive does. And I think, quite apart from it being sort of them trying to improve judicial review, this is their assault on the rule of law. I mean, it's not surprising, but it is what it is, because some of the proposals are just retrograde proposals that restrict and preclude ways in which executive power can be. Everyone should get involved, basically. Trying to object to this is my sort of general message.
Thanks.
I mean, I would add my concerns to it. I mean, this comes after years and years of making judicial review much more difficult for all of us. You know, with the cuts to legal aid funding, you don't get funding until you get permission. It's, you know, it makes everybody's jobs a lot harder. So it is quite concerning, you know, what may come out of all of this. But I mean, my experience is that the courts seem to be at the moment more and more cautious in responding to judicial review claims, and that may be sort of the courts anticipating the, you know, the potential you know, impact of the government's concerns, and issuing more cautious judgments, giving a little bit more leeway to the executive at the moment, and particularly during the coronavirus pandemic.
Do you think that was part of the judgment in your case, the detention action case? The government was that the court was loath to be seen to be interfering with government decision making at such a kind of moment of crisis?
Yes, I think so, and I think that sort of subsequent decisions have shown that the court to continue to be cautious, which makes it very difficult for all of us, you know, to bring cases, and we've had to think very carefully. You know, there's been various organisations thinking about bringing similar challenges after the detention action case in various different spheres. So, for example, in the prison context, but having to think very carefully about what evidence the government produces, how much time the government's given to respond, and the court's likely response to that has definitely impacted on the types of claims that are brought. Because I think something has been covered earlier on in our discussion. You know, when you're bringing strategic cases, you have to think very carefully about whether your likely outcome is actually going to be helpful, or whether it's going to be neutral, or whether it has the potential to make things worse. And it's really important to consider that when deciding whether to forge ahead, or whether or not, you know, you've got to just accept it and say there isn't a viable challenge, or there isn't a strong enough challenge. It's just too risky at the moment.
So we've got two questions in the Q&A that we haven't addressed. The first is about whether anyone's got any suggestions for ways in which you could get experience in the field of strategic litigation as an immigration caseworker rather than as a lawyer. Sorry, hoping to become an immigration support caseworker, but not currently doing that. I mean, I think Becky's kind of addressed this already when she was saying that you don't have to be a lawyer to be involved in this kind of work. I mean, as a support worker, as someone working in the NGO sector, you're coming into contact with people who are experiencing the kind of sharp end of unlawful government policies all the time, and so you can make a difference by identifying those issues as a non-lawyer. But I wondered if Becky particularly had any other suggestions for how you could kind of get experience in the field of strategic litigation before qualifying.
Sure. I guess that's what I was saying. I think that there's no set career path for people, and I think especially juniors coming up through law now, it's almost so intimidating. It's like, right, I have to have done this by this age, I have to have a training contract by this time, or got pupillage here, and it's just not the way it has to work. And I think firstly, relieving yourself of that pressure can really help. Obviously, it's frustrating not doing what you want to do, but I think there are lots of ways to get there. And if you have a specific area that you're interested in, whether that is detention or working with a specific group of asylum seekers, or like in my case, it was victims of trafficking, I think you can look at areas for opportunity to be involved in that sector, whether that's in a legal capacity, a policy capacity, a support capacity, because all of that experience is so valuable and it will really contribute to your legal career. I mean, you might as well. There's no harm. And even if it's just volunteering for, once a fortnight in the sector and just learning from those. And I also think it encourages the sectors to be talking together. And it's something that I notice when we do it well, when the legal sector talk well with the NGO sector and with the media and with the public, we can really achieve a lot. And some of the examples that were raised today, show that, but we're still not very good at it. And so learning to intersect between the worlds, even in our own little forums, can be really, really beneficial. So I would encourage that as an option, but also don't be discouraged. It's a hard time, and I don't think it means that the options will close forever, but definitely keep trying, keep pushing on doors.
Yeah, I mean, I would just again echo that and say, I mean, I just talked about the importance of evidence, and working for an NGO, you'll be working in the kind of organisation that's providing that evidence to the lawyers who are running the case, and that's the kind of really invaluable frontline case studies that you need in order to support a piece of strategic litigation.
I think it's not also just providing us with the evidence, but it's also sometimes identifying the problems that we're not necessarily aware of because we're not doing the kind of hard graft on the ground. So discussing with us ideas about, working as a support worker in the immigration or trafficking field, you'll gain first-hand experience of issues that you think there might be something wrong with this. Is there potentially a legal challenge? And discussing it with solicitors, with barristers. That's how these cases start. So you can be involved in strategic litigation, coming at it from a number of different angles.
Yeah, that leads us really nicely into the next question, which is how do you ensure that strategic litigation empowers disenfranchised and marginalized people, and is there a risk that lawyers take control of campaigns? And I think it's a really good question, and I think it's probably a really difficult balance to get, as we've talked a bit about the kind of potential conflict of working with vulnerable people when you, as a lawyer or as a legal organisation, has a particular outcome in mind. But yeah, I'd be interested to hear from the panel whether they've got any other thoughts on that.
I think it's an interesting question because, having worked with quite a few organisations on different kinds of strategic litigation, they may have a campaign front-facing, objective that doesn't quite marry up with what they need to package in the context of a legal challenge, and that can be challenging for organisations because what they can and cannot say on Twitter and social media and to the press could be affected by where the stage at which the litigation is at. Is it pre-litigation, is it post-litigation, or is it in the midst of litigation? What you can say, it does matter, and there is sometimes that tension between the organisation staying true to itself as an organisation doing whatever the work it's doing and litigation. And it may be that not all organizations are cut out to be the claimant, but they may be the supporting role in litigation by either identifying the individuals who are affected, referring them to solicitors, or providing the important evidential context for a piece of strategic litigation. I mean, Aisha's mentioned that, you know, in the detention action case, it wasn't just detention action producing the evidence, it was a whole load of other organizations also doing it. And you can still play a participatory role without being sort of in the spotlight, so to speak. So it is a difficult tension to strike. And I don't think that it necessarily is the case that all organizations should think about themselves as litigators, so to speak. But sometimes they can offer very important insight that otherwise lawyers don't have access to. And I mean, lawyers also need to be alive to the idea that organizations have their own trustees and their own objectives, and they also need to strike the right balance. So it's about communication, I think, at the end of the day, to make sure that everyone's on the same page. Yeah.
I was just going to say that I think sometimes it might have happened by accident that the legal sector or the lawyer has become sort of the face and the mouthpiece of something. But I think part of that actually might just be because of the really sensitive subject nature. So the client wants to be confidential and has every right to be confidential and isn't going to be like the poster girl or boy for that issue, and nor should they have to be. So I think sometimes maybe it even looks bad taste, but it's meant with good intention. And the other time is just the independence of the legal profession, which is so important. But often, like Shu touched on, many organizations have got different funders with different objectives or have a different political stance on something, where the legal profession is independent. So that gives us a platform, perhaps almost by accident, to be speaking out on things because we're not political about it, we're legal about it. It's a different topic. Again, though, we just have to be sensitive and careful how we do it and make sure we're communicating properly, and can continually be doing better at that, I think. The only other thing I wanted to touch on quickly was Young Legal Aid Lawyers' recent campaign, which I think many of you might have seen on Twitter and might have tweeted your MP, for which I'm very, very grateful. But I think that was a good example of where it was helpful for us as lawyers to be involved, because the regulations were really technical, the change in the regulations around the immigration fee. But then when we liaised with I'm not saying that people can understand it, but more just like, it's boring. It's very much like, why would the average person, it's a very hard message to distill down to the impact. So with us being able to like break down that message, and Ilpa did a lot of work on this as well, and then communicate the fallout to the NGO sector, who then could communicate the fallout from their clients to the public and to wider groups. It was a really good transition of information, and I think working in collaboration is really important to be able to break that down. Because I honestly think that some laws are made to be complicated because it's a barrier. Like welfare law, it's a nightmare. And I'm like, this is my opinion. I think that's why it's important that we all work together, because why should everybody have to learn that entire statute? It's not everyone's going to do that. So yeah, just playing the part with wisdom and communicating clearly and thinking about what the goal is always important.
Yeah, I mean, I'm just going to speak from my experience, just to kind of say that I completely agree with what everyone has said about communication and collaboration being so important. I mean, in my sort of short career to date, there have been issues that we've identified as lawyers, which we've thought, well, this seems really, really unlawful. Let's litigate it. And then you start talking to grassroots organisations, to individuals, to NGOs who work in that sector, and they're like, well, I mean, the law maybe is problematic, but actually it's not affecting our clients in this way. It's not actually a problem for people. And so I think the most important thing that you can do is listen to the communities who are affected, to kind of have those relationships with the NGOs who are working with individuals on the ground, and to really listen to them and try to understand how policy which you might have identified as being unlawful actually impacts people before you start to think about whether or not you should be challenging it. There's another question which is about, how do you look after your mental health during a strategic litigation case, considering the impact transcends the particular client and that you as a lawyer may feel more emotionally involved? Does the collaboration aspect offer any support in this regard?
I think that, like, knowing that you're working as part of a team and that you're all in it together is really helpful. You know, when you're when you're putting in the long hours, and you know, potentially if you lose a case as well, it's, you know, it can be tough, and it can be tough to continue to have to appeal cases and appeal cases in the hope that you're eventually going to get the decision that you consider to be the right one. But I think also it's about kind of finding time to kind of, you know, take care of your own well-being and be good to yourself outside of the work that you do, recognizing that, you know, you're not going to be able to put in the kind of you know, the emotional effort, the mental effort into your cases if you're not kind of being kind to yourself. And, you know, if you're working all the time, it's going to affect you, I think. But then I think also, like for me anyway, like winning, when you do win a case, it definitely gives you a boost to kind of keep going for the next 6 months. Keep working at it, and you know, in the hope that the next case you'll win as well.
I think in the immigration context, there has been a real push to get training on vicarious trauma. Just in terms of, it transcends sort of strategic litigation, but just litigation for individuals, and in high pressured situations where they've had challenging experiences in trafficking, in the torture context, and in asylum seeking context as well. And I would encourage people who are coming into the law to do that training on vicarious trauma, particularly if you're going into being a solicitor and working as a paralegal or trainee, because you're the front-facing people who are dealing with clients on a day-to-day basis. You're going to hear things, read things that are that you think, well, it's my job, but it actually does impact on people in ways that are very subtle. And I think that's another way of sort of having some structural support and tools to deal with it as and when it comes is quite useful as well.
I was just going to quickly add to that. I definitely agree with all those statements, but I think don't be afraid to set the culture that you want in your workplace. So don't apologize for taking a lunch break. Don't apologize for, you know, going home on time. Like, that's okay. And it's almost, that's across the profession. And of course, yes, in litigation, there's times where it's hard graft and you've got to knuckle down because of your deadlines. But that doesn't mean that you have to be like that all the time. You have to take a break. And, you know, there's no prizes for being a martyr. You're no good to anyone if you're burnt out. So, yeah, I definitely think that if we want to see this whole profession actually be better at looking after ourselves and each other, then we need to start setting good personal boundaries, and that gives other people permission to like set good personal boundaries too. Because they'll look at you and they'll say, oh, she takes a break, it must be fine. So I would say that.
Thanks, Becky. Yeah, I mean, I can't emphasize how much I think that's really, really important, and something that we should all be thinking about. And since it's a YLAL event, I'm just going to do a quick shout out for Claiming Space, which a lot of you I'm sure will be aware of, was founded by an ex-YLAL co-chair, Rachel Francis, and holds monthly, I think, meetings for junior practitioners to kind of share in a confidential space. So look them up, that's Claiming Space. We don't have any more questions. We're not quite at time yet, but unless anyone's kind of got anything else they want to add or anything they want to end on, I think we'll wrap up now. So I'll just ask the panelists if they've got anything else they want to add.
Just a thank you to you, Katie, for organising it, and all the conference organisers. It's been a really great conference, and obviously a few more days to go. So amazing work. Thank you.
Thanks. Okay, great. In that case, I'll just say the next session in the festival or conference is tomorrow at 6:30, and that's on racial inequality in the criminal justice system, which should be really super interesting. So try and join us for that if you can. And thanks to Becky and Shu Xin and Aisha for joining us, and to Zoe as well, who actually sparked quite a lot of interesting conversations in our planning for this session. So it's a shame that she wasn't here. But thank you all, and hopefully see you soon.